Thank you, and good afternoon, and thank you all very much for joining us and taking time out of your busy schedules. And welcome to the first of our series of Countdown to the UPC webinars. Next week, there is a hearing in the European Court of Justice concerning the Spanish challenge to the Unified Patents Court. Subject to any surprises arising from that, the Unified Patents Court is going to be a reality, and we're not expecting anything untoward to come out of that, and we're certainly proceeding on the assumption that the Unified Patents Court will be with us before too long. As many people know, the Proprietary Committee recently gave an estimate of not before the end of 2015 for the court to be up and running. And end of 2015 is looking rather optimistic at the moment, but momentum is certainly gathering towards the stage when the UPC will be able to open its doors for business. Ratifications are underway. We have ratifications from France, Austria, Belgium, Sweden, and we believe Malta. UK is in the process of ratifying, and several other countries will follow suit. And of course, just to remind everyone, we need to get up to that number of 13 ratifications to include France, Germany and the UK as the largest recent patent filers. Germany has now declared its 4 local divisions. Plans for the first regional division have been announced, namely a Baltic regional division comprising Sweden, Estonia, Latvia and Lithuania, based in Stockholm and with English as its languages. The interviewing of judges is underway, and the draft amendment to the so-called Brussels regulation to take account of the UPC has been published. Practical matters such as IT systems, buildings to house courts are currently being addressed. With all the possible study and scrutiny of the detail of the agreement and the draft rules of procedure, how the court will function in practice still, of course, requires crystal ball gazing. A huge amount will depend upon the judges and how they run the court. As I mentioned, the judicial interviewing process is underway, and so far as we can understand it, it seems likely that many of the experienced patents judges in Europe will serve in the divisions of the UPC. This is obviously good news, although it is likely no one presently knows precisely how they will divide their time as between the UPC and the national courts. Also, our understanding presently is that necessarily judges will also be drawn from countries that traditionally have had fewer patent cases. The balance between balance in the pool of judges between those with more patent experience and those with less is something that will only become clear in due course. So in that context of crystal ball gazing and waiting and seeing, for the first of our UPC Countdown webinars, we have selected a topic that is certainly deserving of early consideration, namely the transitional regime affecting the so-called classical European patents, that is, the non-unitary or bundle patents, if you like. That is the potential parallel jurisdictions for EP patents during this period, and the related but distinct topic of the option during the transitional period of opting these classical European patents out of the system entirely. In terms of structure of this afternoon's session, I will hand over in a moment to my colleague here in London, Paul England. Paul will explain the detail of the transitional provisions and the opt-out rather more than I have done in my brief outline. After that, my colleague from Düsseldorf, Christoph Hörner, will then discuss certain aspects of the regime, namely how it applies to supplementary protection certificates, the procedure to opt European patents out, and the so-called sunrise provision. I will then conclude the webinar with some thoughts and considerations on the $64 million question, whether to opt out or not to opt out. If you have any questions or comments as we go along. We do, of course, welcome these. I mean, we're conscious that we are addressing an audience of some very experienced patent litigators who have handled cases in a number of different jurisdictions. So we very much welcome your sharing your views and comments with us. And insofar as questions are directed, we will endeavour to reply to those as soon as we can. So with those preliminary remarks, I will now hand over to Paul.
Thank you very much, James. Well, to understand the transitional period and the opt-out, it's first necessary to step back a little and look at how the UPC will fit into the general European patent system. This is because the UPC is not going to exist in isolation, but side by side with the national courts. And this is what we're showing in the first slide. Now, whilst technically the UPC is actually a court of the member states, it's actually easier to think of it separately. So a simplified version of the UPC is shown on the left, with its regional and local divisions represented by the orange box, the central division by the green box, and the Court of Appeal by the dark blue box. And each of these divisions can refer questions to the Court of Justice of the European Union, which is at the top. And referrals are likely to include the same matters that are referred nowadays, including SPCs, the Bolar exemption, and the Biotech Directive, for example. On the right-hand side of the slide are the national courts. These will continue to exist after the UPC becomes operational, but they will be of three different types. Firstly, there's the national courts of the 25 member states which are contracted to the UPC. Secondly, the courts of the 2 member states that have not signed the UPC, which at the moment are Spain and Poland, and that's the pink box. And then thirdly, there's the black box, which is the national courts of the countries that are signatories to the European Patent Convention, but can't join the UPC because they're not European Union member states. So unlike the other courts shown, those courts can't refer matters to the Court of Justice. Now, incidentally, Croatia, which is the newest EU member state, isn't included in this picture. And that's because it remains to be seen at the moment whether it will actually join the UPC, although I should add that it is expected to. So the transitional period and opt-out that we are talking about in this webinar is only concerned with the relationship between the UPC, on this slide, and the national courts of the first type that I described on the slide, that is the white box. At the same time the UPC comes into force, it's also going to be possible to start obtaining European patents with unitary effect, what are referred to as unitary patents for short. This means there will be 3 types of patent available in Europe. Firstly, unitary patents. Secondly, the existing form of European patent that James referred to, which are now often described as classicals, and national patents. So the question is, what form of patents can be litigated in which type of court in the new system? As regards national patents, these will continue to be actionable in the national courts only, regardless of the UPC being introduced. And by national courts, I mean all of those types that I described on the previous slide. The unitary patent disputes, on the other hand, will largely be actionable in the UPC, most notably for infringement, non-infringement declarations and revocations. But there are exceptions to this for matters relating to unitary patents as objects of property and in certain other respects, such as unjustified threats actions. On these latter matters, they're going to be actionable only in the national courts of the contracting member states. So on the slide, the blue stream at the top shows the forum in which unitary patents will largely be actionable over time. That is, in the UPC, as indicated in the column on the left. Whereas the grey line at the bottom shows the forum in which national patents will be actionable. As the column on the left says, this is the national courts forum. And this is going to remain the situation indefinitely after the UPC comes into force. However, the picture with classical European patents is altogether more complex, as the following slides will show. So this is where the transitional period becomes relevant. Eventually, the intention is that all classical European patents will be subject to the exclusive jurisdiction of the UPC for those matters that I just mentioned that the UPC has competence for. However, because the UPC introduces such radical change, a period of adjustment called a transitional period is going to be introduced in which patentees have some control over whether their patents are subject to potential actions in the UPC or not. And this period is going to initially last for 7 years, although it could be extended by a further 7 years depending on how much the court is used. Now, Article 83(1) of the UPC Agreement is the important provision for the transitional period. This provides that during the 7-year period, a classical European patent may be enforced or subject to a revocation action in either the UPC or the national court of its designation. Article 83 then goes on to say, that paragraph 3, which you can see in the middle of the slide, that during this 7-year transitional period, the proprietor or applicant for a classical European patent may, if they wish, opt it out of the exclusive competence of the UPC. Importantly, however, if an action relating to the patent has already been filed in the UPC, then that opt-out is barred. And finally, in paragraph 4 of Article 83 at the bottom, a right to withdraw the opt-out is provided. So, what do these provisions actually look like? Let's return to the diagram of forum over time and add classical European patents to it. So, during the 7-year transitional period, classical European patents can be litigated, as I said, in either the UPC forum, which is the top purple stream that you can now see on the slide, or the national court of the contracting member state of their designation, which is the bottom purple stream. And note that this provides for dual jurisdiction and the possibility of conflicting actions during the transitional period, something which the Brussels I regulation has recently been amended to prevent. However, once the transitional period has expired, which I've indicated on this picture by the use of the dotted line, all actions concerning classical European patents must then be started in the UPC and the UPC only. This is represented by the bottom stream, the bottom purple stream, heading up to the UPC at the top. Although, as again an exception, which is that any action that is already on foot in a national court relating to a classical European patent must continue in that national court. Now, all of this picture is how things will work unless the classical patent family concerned has been opted out. So we need to move on to look at what the opt-out does. The additional pink-grey stream that's in the slide now shows the effect of the opt-out on the forum in which a classical European patent must be litigated. This stream descends from the UPC forum down to the National Court forum, indicating that the National Court is the only forum in which an opted-out patent can be litigated. Here, for convenience, the opt-out is shown as taking place as soon as the transitional period starts, but it could actually be exercised at any time up until the expiry of the transitional period. But remember, after expiry of the transitional period, the opportunity to opt out is lost. Now, it's currently understood that an opted-out classical European patent remains opted out until it, or any SPC based upon it, expires. And in fact, this opt-out for life is confirmed expressly by a note in the 16th draft Rules of Procedure. The next question to consider is the effect of withdrawal of the opt-out, as shown in the next slide. The effect of withdrawal of an opt-out under Article 83(4) of the UPC Agreement is to take a hitherto opted-out classical European patent back within the exclusive competence of the UPC. And the UPC Agreement says that an opt-out can be withdrawn at any time, which means that an opt-out can still be withdrawn after the transitional period has ended. The only restriction on withdrawal is when an opted-out patent is already the subject of litigation in a national court. This litigation must continue in the national court in question. Although it's currently unknown whether the opt-out can be withdrawn after such an action is fully completed. Now, to explain the opt-out procedure, I'm going to hand over to my colleague in Dusseldorf, Christoph Herner.
Great. Okay. Thank you, Paul, for providing this background information. As you said, I will now turn to some of the details of the opt-out. But before discussing any formalities of the opt-out, as you've already mentioned, Paul, we now are dealing with the 16th draft Rules of Procedure, which means that there have been 15 previous drafts and there's still a lot of confusion. And now the 16th draft of procedure has provided a lot of clarification also, or in particular, with regard to the opt-out. We've talked about classical European patents before, and of course the question arises, what happens if the patent expires and there's a supplementary protection certificate? What happens with the SPC? And the new Rule 5.2 has now clarified the situation. The basic rule is that the SPC always follows the patent. So if an SPC is to be opted out, it's only possible if also the classical European patent on which it was granted is also opted out. This is also possible even if the European patent has already expired and only the SPC is currently in force. And further, because the European patent also has to be opted out alongside the SPC, or because the SPC follows the European patent, it's important to get the patentee or the proprietor of the European patent on board for filing such an opt-out. So if there's a situation where the holder of the SPC is a different party than the proprietor of the European patent, it's only possible to opt out the SPC if the patent proprietor participates and files the opt-out alongside the holder of the SPC. Just for means of clarification, the opt-out only relates to classical European patents and SPCs granted on the basis of these classical European patents. So SPCs relating to future unitary patents cannot be opted out. In this regard, it has been discussed now that, or it is seen, of course, that for unitary patents there will also be SPCs, but SPCs are currently granted as a matter of by national legislation, or it's a national approval of individual SPCs. There's not one harmonized central SPC that is granted for all states. The European Commission is now very much aware of this, and now with also the upcoming unitary patent, it has been discussed if there should be a central SPC that can be granted for unitary patents, but this is something that still needs to be agreed upon. So now we've looked at a very detailed part on SPCs. Let's now focus on the basics of an opt-out. So how does it work? An opt-out is possible for a classical European patent or a patent application, so an application that has not yet been granted as a patent and has the effect to also extend to an SPC. If an opt-out is to be filed, an application must be lodged with the UPC registry, which is going to be set up. This application must, on the formal side of things, disclose details of the patent and application and SPC, so basically the formalities, the number, also the names and addresses of the proprietor or proprietors, respectively applicants, has to be submitted. important, nothing is for free. Of course, a fee is required that has to be paid for the opt-out. At the current stage, it's not yet clear how high this fee will exactly be. This will be announced at a later date. The opt-out itself will only become effective once it's registered in the UPC registry. Now, of course, as you may know, under the unitary patent, there's a risk of a central revocation action, and this, of course, can have downsides for the patent proprietor who says, I want to opt out my patent, but run the risk that on day one of the UPC coming into force, somebody will file a central revocation action and has the chance to completely nullify my European patent. So he, of course, the patentee, has an interest to be the first to be able to opt out before any central revocation action is filed. The preparatory committee has taken account of this conflict and also of the clashes that will take place on day one, where numerous applications for opt-out will be filed and numerous applications for a central revocation action. And of course, it wants to avoid any disputes and gives the favor to the patentee and provides in Rule 5, Paragraph 13, a so-called sunrise provision. During the sunrise provision, which is a date before the official entry into force of the unitary patent, an opt-out by the patentee or patent proprietor can already be declared. Now, of course, the UPC is not set up yet at that point in time, so the question is, where can this sunrise provision opt-out be filed? It has been decided that it can be filed with the EPO, the European Patent Office, because, of course, it has a running computer system and logistics before the UPC registry will do. So the application for an opt-out will be filed with the European Patent Office, and the European Patent Office will also collect the opt-out fee once it's been published. It will then forward the opt-out to the registry, which will, once the UPC comes into force, submit it in the registry so that the opt-out is effective before the unitary patent agreement or the unitary patent court actually starts. A question that has arisen now is if during this sunrise period applications for an opt-out are filed, if these will be publicly, can be accessed publicly, if this is public information, or if it's sort of kept in the background and only on the first day of the unitary patent, when somebody clicks on the website of the registry, will they see which patents are opted out, or if there's sort of a way to prepare beforehand. So we've looked at some of the formal details. Another thing that really needs to be considered is who can file an opt-out application. Of course, generally it's the proprietor of a patent. The situation becomes interesting when you have more than one proprietor of a patent, or you have a European patent in which national parts of this patent, which are also contracting states, are assigned to different holders. So in this case, it has now been set out in Article 5.1b that all proprietors of the patent of all contracting states have to sign the opt-out. This is also a very consistent approach, because it's independent of which countries have actually ratified the unitary patent, because you would have otherwise a situation where only some member states have ratified, and only for these countries would an opt-out be declared, but subsequently, when others become members, subsequent opt-outs for the same European patent or national parts of this European patent would be required. So the rule is all proprietors have to sign the opt-out. And further, it's not possible to pick just several countries that can be opted out. It has to be the whole classical European patent and all designated contracting member states. Now that we've looked at how an opt-out is filed and who can file an opt-out, one thing that also can be considered is what about the exclusive licensee? Is he in any way involved in an opt-out? Does he need to consent to an opt-out? So this question may arise against the background of Article 47.2 of the Court Agreement, under which the exclusive licensee can bring own infringement actions from a patent. So he's basically behaving like a patent proprietor. So this rule may give rise to the thought that also the exclusive licensee would have to agree to the opt-out. However, if you look at Article 47.2, it says, of course, the exclusive licensee can bring his own infringement actions, but he has to give the patent proprietor prior notice, so he's not completely on his own. And further, when you now look at Rule 5, which deals with the opt-out, the wording does clearly not include the exclusive licensee. It could have been included, but it wasn't included. And further, the exclusive licensee is somebody who's dependent on the patentee, so he's deriving his rights from the patentee. If he were to terminate the license contract, the exclusive licensee wouldn't have any more rights. So against this background and also some practical concerns, if you have different licensees for different fields of use, you would have to have all exclusive licensees to agree. I think there are very good reasons available that the exclusive licensee does not have to consent to the opt-out. He's bound by the opt-out of the patentee. The problem is, or what should be considered, is when you close a license contract with an exclusive licensee, that you deal with the issue of an opt-out, because the exclusive licensee, if this is not dealt with, may at some point start to argue, well, I always thought I could enforce the patent centrally now that the unitary patent system is up and running. And I don't know, this may give rise to potential termination of a license contract or just some disputes. So it's good to think ahead, well ahead, and say that in case of an opt-out, the exclusive licensee will be informed, or that the exclusive licensee is aware of the fact that the proprietor can opt out at any time. Okay, now everything has been done. You have filed an opt-out. It's clear who's filing the opt-out, and the exclusive licensee is not involved. The question then arises, what effect does this have? Article 83, para 3 of the Unitary Patent Court Agreement says that you opt out from the exclusive competence of the court. So then it means you can't go to the Unitary Patent Court anymore. So you have to go to a national court. But the question is, what law does the national court apply? Does it apply national law, or does it also apply the Unitary Patent Court Agreement? There are two ways of reading this this provision. One provision says, one interpretation says you opt out from the exclusive competence of the court. That means you opt out from the court, and of course, in turn, following that, also the law, the agreement. This would have the effect that the national court that you have to go to would apply national law. The other interpretation says the agreement, or this clause in the agreement, only talks about opting out from the competence of the court. It does, however, not mention the law that you opt out from. And so the national courts would also have to apply the Unitary Patent Agreement. Now, there are some first thoughts on this aspect. The preparatory committee has more or less, on January 29, they've published a statement on this, said, we take the position that this is meant, the opt-out is meant to include the court and the law, and said the national courts can only apply national law, otherwise there would be some severe risks because the unitary patent law or patent agreement would be interpreted by so many courts, and there would be no consistency, and this can only be assured consistency if it's handled by the Unitary Patent Court. The other interpretation is more or less held by some authors, like Professor Tillman, who's also in the drafting committee, and he basically states, just by taking it from the literal wording, the provision only states that the opt-out concerns the competence of the court, but says nothing about the law. So the national courts should nonetheless apply the Unitary Patent Court Agreement. Of course, at the present point in time, this is nothing that either the preparatory committee or the authors can decide. In the end, it's the national court that you have to go to once the patent is opted out, who decides which law it chooses to apply. Of course, there's a further possibility that the preparatory committee will provide further clarification on this point, but it has not done so yet. Nevertheless, I think good reasons are available that this opt-out concerns the court and the law. So now you have to decide if you want to opt out or not, and for that, I will hand over to my colleague James Marshall in London.
Thank you, Christoph. So to conclude this afternoon's webinar, let's return to the key question, to opt out or not to opt out. And that is a question that many patentees are going to be faced with and are going to be considering over the next year or 2 years before the court opens for business. And there probably is no single answer that will suit all patentees. And quite possibly there's no single answer for one patentee for all its patents in its portfolio, and it would not come as a surprise that some patentees would decide to opt out some patents and not to opt out others. And of course, it is a dynamic situation, as Paul was explaining. Although you can opt out on day one, you can withdraw the opt-out subject to the existence of a pending national proceedings. The pros and cons of opting out are of course quite obvious. Opting out means losing the ability to enforce on a pan-European basis in a single set of proceedings. And this, after all, was probably the whole point of the court. And for years and years, we in Europe have been trying to devise a system where pan-European enforcement and pan-European revocation can be determined in a single set of proceedings. Not only is multiple jurisdiction patent litigation that much more expensive, but as everyone who's been involved in it will no doubt testify, the challenges that are required in managing these projects, when the jurisdictions have different procedural foibles, sometimes quite big differences in procedure, usually quite big differences in timetables, these challenges can be quite substantial. It's of course crucial when managing a pan-European or pan-jurisdictional dispute that positions taken in each jurisdiction are consistent with others, and resources and efforts have got to be directed where necessary, having regard to where and when the more intense phases arise. Naturally, in a single set of proceedings to enforce throughout Europe, many of these, shall we say, project management issues will disappear, if not all of them. In real life, of course, the disputes very often extend outside Europe. Of course, the only reason for opting out classical European patents is to avoid the possibility of revocation in all member states in one go, as Paul and Christoph have been discussing. One only has to imagine the feeling of a patentee on day one of the new court when that pan-European revocation action lands on his desk. I think the concern will principally be one of uncertainty. What is going to happen in this brand new court? Based on all our experiences, and all of us who've been involved in patent litigation over the years, we all feel we can gain a reasonable idea with the help of local knowledge of what would happen in, say, a UK revocation or French, Dutch, or German nullity action, broadly how long it would take, how much it would cost, and most importantly, we feel we're pretty well placed to be able to gauge the chances of success. But with this new court on day one, we will naturally feel some extent in uncharted territory. Cost of opt-out cannot, of course, be ignored, and Christoph has mentioned there will be an opt-out fee, but crucially we don't know what that is yet. And even if reasonably modest for a single family, that could add up to a sizable figure for a substantial portfolio. To my mind, though, there is another factor in the decision, and the importance of which will probably increase in time. Very often, it is important for a patentee to demonstrate confidence towards would-be infringers or potential licensees of the strength of patents in a portfolio. Patentees certainly would wish to avoid giving the impression, rightly or wrongly, by opting out, that they have concerns about possible revocation. In the early stages, before the court had any sort of track record, the decision to opt out probably will not be interpreted in this way. But perhaps later in the transitional period, it may be worth assessing what message is going to be communicated to would-be infringers, potential licensees, by a decision to opt out on a large scale. Will it be perceived as overly defensive? As I say, that is a factor that probably will change in importance over time. For all these reasons, our best guess, and indeed our impression from speaking with others, as we all together begin to feel our way in this new world, is that a lot of companies will be cautious to begin with, and probably start off by foregoing some of the benefits of the new system by opting out at least some, and in some cases possibly all, of its European classical patents, with a view later, gradually perhaps, to withdrawing the opt-out and letting more and more back into the UPC system as confidence in the system grows. As Paul has explained, remember though that opting back in is not an automatic right. If national proceedings have been started that involve an opted-out European patent, it will not be possible to opt back in, at least while the national proceedings are pending. As I mentioned at the outset, and as Paul has touched on as well, during the transitional period, the opted-out patent, the non-opted-out patent will potentially be subject to parallel jurisdiction in the UPC and in the national courts. As mentioned, the provisions of the Brussels regulation are to be amended to extend the so-called Lis pending arrangements to address this parallel jurisdiction and extend it to a classical European patent during the transitional phase, so as to give a framework by which the court second sees, whether that's the UPC division or a national court, can decide whether it has or whether it should stay its proceedings. How these provisions will work in practice, in the particular case of, on the one hand, a national proceedings involving one designation of a European patent, and UPC proceedings involving all designations, depends on how you interpret the regulation, on the draft amended regulation. And to my present way of thinking, there are potentially different outcomes in this situation. This is not a straightforward topic, and we intend to return to it at a later webinar, but equally we would be happy before then to discuss this aspect offline with anyone who has a particular interest in it. That then brings us to the end of our first UPC Countdown webinar. On behalf of Paul, Christoph and myself, I would like to thank everyone who has taken the time to log in and participate. Appreciate that everyone has very busy schedules. We very much hope you found it helpful, and we would be very welcome to take any questions or share experiences in the future. So thank you very much indeed for your time.